we have highlighted the relevant part, which is the effect of what I'm saying. In summary, my lord, their lordships are saying the law is concerned with the winning candidate. There is no logic in pursuing the losing candidate. The law is not concerned with that. So it is irrelevant when we are arguing this ground that the petitioner may have, as I saw the counsel for the first respondent try to bring out at some part of the examination. Now, my lord, in paragraph 7.3, that's at page 4 of our petition. The petitioner pleaded a number or several elements of non-compliance with the law. This is in the petition at page 4 of that petition. Several elements of non-compliance were pleaded there. I may not repeat them, my lord, because they are already in the petition. Summary may be, or it may suffice for me to say, that the complaint was about the holding of the election in an environment that's not free and fair, the non-counting of votes cast at these polling stations, the 14, my lord, the non-transmission of results, the non-filling of the DR forms, the non-tallying of these results, non-delivery of the tamper-proof envelopes, and final declaration of a winning candidate without receiving all envelopes from the constituency as is the command of the law. That was the substance, my lord, of the elements of non-compliance with the provisions of the law. My lord, in the petition, we specified the provisions of the law which were breached. What did the respondents do in their answer? First, my lord, of course, my lord, I could also probably mention that the petitioner gave evidence in support of those claims together with her agents. Now, in answer to the petition, let me begin with the first respondent. What does he say? In paragraph 4 of the answer to the petition, he says, yes, there was 0 return from those polling stations. My lord, that concession in paragraph 4 of the answer to the petition is repeated in paragraph 6 of the affidavit in support of the answer to the petition. When he was here for cross-examination, my lord, he told us that he had polling agents at all the 197 polling stations, and that none of them had come back to tell him that elections did not take place in these 14 polling stations. Pressed further in cross-examination, my lord, he admitted, 1, that there was non-counting of votes. He admitted, 2, that the other forms were not filled. He admitted from the look of the tally sheet that the results were not there. All of those elements of non-compliance were admitted while the first respondent was on the stand. Now, for the second respondent, paragraphs 10 and 11 of the answer to the petition, paragraphs 10 and 11 of the answer to the petition, and paragraphs 9 and 10 of the second respondent's answer to the petition admit a greater majority of those elements of non-compliance. Admit a greater majority of those elements of non-compliance. My lord, we will retreat and read those paragraphs. You will see what I'm saying. Further, my lord, the second respondent filed 5 other affidavits. When you gave them leave to do so, they filed 5 other affidavits of Ahawe Fiona, Peace Shogabiwe Mugabe, Kamsime Tuhemba, Kamare Simon Peter, and Kakaire Gavastas. All those affidavits were filed on the 5th of May by your leave. Now, my lord, the silver lining that cuts across all of these 5 affidavits, which are the evidence of the second respondent, is that 1, there was no counting of the votes at these polling stations. 2, that as a result of violence, this counting was not completed, and therefore that no DR forms were filled at these polling stations. This was the evidence of the second respondent. And from that body of evidence, my lord, starting from the petitioner, the concessions of the first respondent, the concessions of the second respondent, it is our submission that all elements of non-compliance that were pleaded by the petitioner were proved or have been proved. Why do I say, my Lord, that all these things we pleaded were non-compliance? I refer you briefly, my Lord, some of the decisions that have held that each one of those things that we pleaded is non-compliance. Maybe perhaps, my Lord, to tell you that non-compliance simply means that there's provision of the law which has not been complied with, as simple as that. If the law tells you count votes, you don't count them, that's non-compliance. Fill DRR forms, you don't fill them, non-compliance. Take all envelopes before you declare, you don't do so, non-compliance. That's simply what it means. And in the petition, we specified all of those sections that the second respondent did not comply with. They told him to do something else, he did something else. Now, my Lord, I could refer some of the decisions in our bundle of authorities that have held that all of these various things that we pleaded and which we have stated have been proved as elements and amount non-compliance with the law. The first one, my Lord, is at page 543. 543 of our bundle of authorities. This is the case of Apollo Kantinti versus Stella Samaru. The actual holding, your Lordship, is at page 566. Very small line down there. Your Lordship is telling you that if you don't tally, that's non-compliance. Yes, 566. That's where the small holding is at the end of the page. We have highlighted it. The second authority, my Lord, is Joika Furakabatsi versus Anifa Kawoya, Supreme Court. That one is on failure to prepare or fill DRR forms. The actual holding is at page 631 to 632. 631 to 632. 631, 632 is where the actual holding is. There, in very few words, my Lord, dear Lordships, the Supreme Court said DRR forms are mandatory. They are not a matter of form, they are a constitutional command by virtue of Article 86, 68 rather, 68, 2 and 4 of the Constitution. So they held their Lordship, the Supreme Court, in that matter, that DRR forms are not a matter of form. In fact, my Lord, the Lordship went as far as saying if you do not have a DRR form at a polling station, you cannot declare the result of the election, because that DRR form is the basis of the declaration. Next, my Lord, is the case of Acheng Sarah Opendi, same volume. Acheng Sarah Opendi and another versus Ocho Nyakecho. That decision, the holding is at page 678. The actual holding, my Lord, is at 678. There, my Lord, in that decision, as you go there, 15 DRR forms had been tampered with and did not end up at the tally center. The Lordship, their Lordship, so in the Court of Appeal say that the failure to transmit those DRR forms, as was in this matter, no DRR forms were transmitted, amounted to non-compliance. EC versus Moscow, just briefly take you through, my Lord, decisions which have held that all of these things we have pleaded constitute non-compliance. That's what I'm taking you through briefly, my Lord. It's at page 701, same volume, and 701. The actual holding, my Lord, the page I'm referring to as where the actual holding is, but of course the case starts at 686. 686. But the actual holding begins at page 701. Their Lordships were interpreting a section, my Lord, of the Law Governments Act that is pari materia with that of the PEA relating to postponement of counting and tallying of results. They said the EC had that option to postpone counting of votes, as in this matter, postpone voting, as in this matter. They had those options under the PEA, they did not take them, and instead went ahead and declared a winner without those 14 polling stations. That's non-compliance, my lord. It was held in Eastern. My lord, first of all, my lord, if according to the evidence of their own witnesses, they are saying there was violence at these polling stations, and the materials were destroyed, by the way, they say that as well. Now, they could have postponed the election to the next day. My lord, that's section 12 of the Electoral Commission Act. 12E of the Electoral Commission Act. My lord, I say 12(1)(e). That is the section, my lord, that they use. It says the commission shall subject to and for purposes of carrying out its functions under Chapter 5 of the Constitution and this Act have the following powers. E, to take measures for ensuring that the entire electoral process is conducted under conditions of freedom and fairness. My lord, the lordships in the Court of Appeal have said that that's the section that permits them to cancel.
That's the section
That permits them to cancel. My lord, I have not carried, but I will bring it. My lord. Then, my lord, back to the PEA, Parliamentary Elections Act. Section 64 allowed them to postpone polling of the PEA. 64(1), where polling at the polling station is interrupted by a riot or violence or any other event the presiding officer shall adjourn the polling to the next day. Yes, for polling, my lord. Then for...
So in this case, was there interruption of polling? Was there interruption of polling? Or it was just counting?
It was counting and tallying, my lord.
So the polling was uninterrupted?
The polling was interrupted, my lord, as we said. Then my lord, section, yes, then section 76, my lord.
76?
Yes. Section 76, my lord. Maybe it is more direct what you want, my lord. It says where counting, tallying, or recounting of votes is interrupted by a riot or violence or any other cause, the presiding officer or returning officer shall adjourn the counting, tallying, or recounting to the next day. Section 76, my lord. So I'm saying, my lord, they had these options and they did not take them. And that amounted to non-compliance in view of the decision of EC versus Moscow that I've just referred to. Moscow, EC versus Moscow, Jacob. EC versus Moscow, Jacob. The page. Yes, my lord. Yes, my lord. The section I've just read says the next day. Yes, my lord. 26(1). Of the offense, 701. That's where the holding is. 701. What the lordships were saying in Moscow is that they had that option to postpone counting, carrying to the next day. They did not take it. That amounted to non-compliance. My lord, just two more in that area. Amorpol, the decision of Amorpol, versus Okero John Baptist. The holding is at page 718, but the case begins at 706. 718 is where the holding is, but the actual holding is at, no, 706 is where it begins. The actual holding is at page 718. My Lord, that one is about transmission of results. In that case, only one DR form had not been transmitted. It had disappeared somewhere along the way and did not end up at the tally center. Their Lordship said the non-transmission of that DR form amounted to non-compliance. Lastly, my Lord, on this issue is our plea, my Lord, that the winning candidate was declared on provisional results without first receiving all envelopes from the constituency. I rely, my Lord, on the decision of Betty Muzanira Kamkwasya versus Winfred Comhange. That decision is at, the holding is at page 751, but it starts at 744. Betty Muzanira Kamkwasya versus Winfred Comhange. The actual holding is on page 751. And that same volume, my Lord, that we are dealing with. Yes, my Lord. Absolutely, my Lord. Because the law requires, my Lord, that before you declare a winning candidate, you receive all envelopes, all DR forms from the constituencies. The only exception that their lordships have created in this decision of Bank Muzanira is if the results that have not come are officially cancelled. That was not the case. No, they were not. They were not cancelled. The returning officer simply proceeded to declare the winner without receiving all results from the constituency, my Lord, as is the command of section 'Let me begin with the law, my Lord. Section 72, the PEA, which their lordships in Muzanira were interpreting. If you are interpreting in the former section 58, now it is 72, 1. Now it is 72.1. It provides, my Lord, that 72.1 says after all the envelopes containing the declaration of results forms have been received, the returning officer shall, in the presence of the candidates or their agents, or such of them as wish to be present, open the envelopes and add the number of votes cast for each candidate. You do not declare a winning candidate without all envelopes. Now, my Lord, in Bamzanisa, they said, of course, you can begin tallying. Okay, if there is, and that's also provided for in the law. You can begin tallying, but declaration, you do not do so until you have received all envelopes. I was saying that the exception, my Lord, they created is of the decision, my Lord. I'm at page 751 now. 751. I'll get for you the page of the exception, my Lord.
And what makes the results provision.
If they're not complete, my lord, that's all. If a constituency has 197 polling stations and you have results of 170 polling stations, they are provisional.
It's not the case where they say you have 10,000 votes, and after more I'm carrying, the votes maybe 12,000. So in that case, you could say yes, the other 10,000. Now more results are carrying, and total votes cast are 12,000.
Even that, my lord.
That's why you say the provision.
Even that, my lord.
10,000, but now more votes are counted, now total votes cast is 12,000. But in this case, it never changed.
Even that, my lord, which you have said, happened and is unlawful. First of all, what you have just said happened in this case and is unlawful. Okay? At the time of declaration, the results were different. At the time of gazette, the results were different. In Muzalida, the Court of Appeal has said that is unlawful for the returning officer to do, first and foremost. This decision has told you once you issue a return form for transmission of results, you can't touch it.
So you were saying they were different.
So-
Declaration, what you were covered in your evidence.
My lord, I only put the final declaration where that which you are
You don't
saying.
have that in your evidence.
No, my lord. The previous results are, but that was not my point. The point was that because you do not have all 197 envelopes, BR forms. The only implication is that what you have declared are provisional results. I was, my lord, taking you to the exception that you had asked me. That same page, 751, where I am. Just below the second highlighted part, there, my lord, they are saying, unless they are cancelled. And the second respondent did not tell us that they cancelled. They did not. And cancelling, my lord, is not by invitation. We appreciate, my lord, after the second highlighted part, down there, after the second highlighted part, down there it says, we appreciate that there are cases where certain results may be missing or cancelled. And the available results are used to declare a winner. None of those applies to this case. They were not cancelled, they were not missed. So that's non-compliance, my lord. So the law commands the returning officer to only. They were not missing. No, my lord, my lord, you cannot miss something that doesn't exist. This was a question of non-existence of that, not missing results. Missing results is this: that results have been declared, like in Nyakechu, Saropen. Results have been declared, the other forms have been filled along the way to the transmission. Then they disappear. The Court of Appeal has dealt with missing results. These were not missing because they were not there in the first place. So I'm saying this therefore does not apply to our case. And cancellation, my lord, is of course you can't do it by word of mouth. Okay, there is a procedure, my lord, if you want to cancel results. And the EC has not said, my lord, that they cancelled. Not at all.
So if they were not there, what is the expectation?
What? Then the question, my lord, would be, what does the law tell them to do? I've just referred you to the law. Postpone. Yes. The voting. Okay, to the next. And how? Because you see, my lord, after the election is held, the law commands the EC to declare a result in 48 hours. They still had time. Yes, so they could have held the election again in those 14 polling stations. The next day, the law gave them that option, and they did take it. Now, my lord, which brings me to the second limb of this issue, which is the issue of substantiality. Now that, my lord, I have told you and have given you authority and evidence that there was non-compliance with the provisions of the law. The next issue is whether that non-compliance affected the result of the election in a substantial manner. My Lord, I will begin with the decision of Elizabeth versus 7. We all know it's a very huge decision, but it's the excerpt I'm referring to is reproduced in the case of Bantali Agakagwawo versus East. Basically of 201. Bantali, where that excerpt is quoted, is at page 818. But the case starts at 793. Bantalibu Isa Agakagwawo versus Isi and Oronedem, 2021. The excerpt I'm referring to of Visa Message is captured there. Page 818. 818 of the second point. My Lord, is 818. That's where the holding is, but the case starts at 790. The case of Bantali Agakagwawo versus Isi and Oronedem. Now, my Lord, permit me, my Lord, to refer to that excerpt. I will not read the whole of it, but towards the end, His Lordship was trying to explain what substantial effect means. He says, that means that to succeed, the petitioner does not have proof that the declared candidate would have lost. It is sufficient to prove that the winning majority would have been lost. Such reduction, however, would have to be as to put the victory to doubt. What does that mean, then, my Lord? It means that in this petition, we don't have to prove, my Lord, that the winner would have lost or that the loser would have won. It is enough in this petition, my Lord, if we prove, and we have, that the number of people whose electoral choice was not ascertained by the Electoral Commission is greater than the margin between the two candidates, between the winner and the first runner-up. That is what we have to prove. I will have established substantial effect, my Lord, if I prove that because of this number of people whose choice we don't know, because nobody knows how they voted, is greater than the margin. My Lord, the margin between the first respondent and the petitioner is 8,881 votes. Those whose choice we do not know, but we are clear voted at the election, is 16,640 votes. They are almost double the margin. They are almost double the margin. 16,640. 640. But the margin.
Can you check the total? When they use this 16,640, 640 from the 16,640.
Yes, I didn't get your question, my Lord.
16,640.
Yes.
The number of total voters is
14 points. Yes, ma'am.
I want you all people there to check the total number by checking
the tally sheet.
No,
Subtracting this from
by
the.
taking by looking at the attach the rows, the voters' rows.
Yes, my Lord.
The voters' rows.
Yes, my Lord.
You can then check out. Also add up all the voting stations.
Okay, they will do that, my lord, as we go. But you can also get. Okay, my lord. But you can also get it, my lord, from the tally sheet. The tally sheet gives you the number of registered voters per polling station and those who vote. If you look at the tally, it would be easier, my lord. But even that they can do from here. But you can easily get it from the tally sheet. Okay. Camouflage, my lord. Now, what I was saying, my lord, is that the margin between the winner and the first runner-up with the petitioner is half of that number, nearly half of that number, at 8,881 votes. When she was here in cross-examination, she probably also say this, my lord, when she was here for cross-examination, and Mr. Mars took her on it quite a bit, the petitioner stated that in those 14 polling stations, apart from the fact that that's where she votes from, in one of them, but those were also her strongholds. And that evidence was not challenged, my lord. My lord, why I mentioned that point is because the case overturned of Kia Moses versus EC and Aliko Herbert of 2021 turned on that point. But I refer to it, my lord, at page 954. It turned on that point. Okay, the appellant in that case said, these areas which have been excluded from voting are my strongholds. It was not challenged at the Court of Appeal, my lord. The case turned on that point. At page 954 of our bundle of authorities. Well, that's now volume 3, my lord. A turn of Kia Moses versus Aliko Herbert. 954, yes, it begins at 9:33, but the holding is at 9:54. In fact, my lord, when she was here, Mr. Laba said, hey, those were strongholds, okay, have the votes, have them. That was and she actually gave them the vote. So the fact that they were not, they were strongholds was not. Now, my lord, let me also give this test, because it might be confused. How do we get substantial effects? Because I saw the first respondent trying to bring another formula when the courts have told us what. How do you get substantial effect? My lord, you do not use the number of people registered in the whole constituency. Why, my lord? For example, in this matter, the results of 183 polling stations are ascertained and unknown, and there is no power with you. So if you want to get whether those people who did not vote had substantial effect, you don't use that number vis-a-vis the total number of voters in the constituency. We are not concerned with people whose electoral choice we know. How do you get substantial effect? You get it by comparing the margin between the winner and the runner-up, who is the petitioner in this case, vis-a-vis the number of those people whose electoral choice we do not know. Therefore, my lord, in this matter, we are comparing 16,640 vis-a-vis 8,881. That vis-a-vis 8,881, which is the margin, yes, between the first respondent and the petitioner. My lord, I am not getting that from my head, but from the decisions of the Court of Appeal, two of them. I'll take you back a little bit. The decision of EC versus Moscow, 2021. That's volume 2. That's volume 2, my lord, at page 702. page 702. That is where what I'm saying is. EC versus Mosuku. Page 702.
What does that assume?
Just refresh my note. Maybe my lord, as I look for that exact holding, I didn't appear to have highlighted it. Let me begin with the Acheng Saro Pendi at page 680. Page 680. In how we get the substantiality effect. Page 680. Acheng Saro Pendi and another versus. When my lord starts at just a minute. Starts at 664. But the holding about this issue, my lord, is at page 608. I have highlighted it. My lord, the point is this. If you look at what we highlighted, what I'm saying is, when you are getting substantiality, you do not take into account the number of registered voters in the whole constituency. So the court said this, my lord. The land judge should have considered the total number of voters in those 15 polling stations. Here the issue was about 15. In those 15 polling stations, which was 7,000, that number, as compared to the winning margin of 7,600 without the same polling stations. And on page 680, we have highlighted that small part there. It's page 680. So that's how we get substantiality. My lord, back to Mosuku. Back to Moscow at page 702. 702. Back to Moscow at 702, my lord. It's paragraph, I think, 445. The one that has 445 at the left-hand side. It's not highlighted, but it says the. The court was trying to find out, my lord, what the number of the registered vote, what the number of those who had not been counted was, in order that they could compare with the margin. Now, my lord, let me underscore what I'm saying. Okay. If they can be looking for it. Now, my lord, let me underscore something as I get away from that point. And it's critical, my lord. That's why I'm going around and about it a number of times. The first respondent's theory is that if you want to know whether the election was affected substantially, you look at the small number of 16,440 vis-a-vis the number of registered voters in the constituency. I am saying that is a wrong test. And I've given you the reason why. my lord, you do not, in that test, take into account the number of people whose electoral choice has been ascertained. In this matter, my lord, the electoral choice that was not ascertained was only to do with 14 polling stations, whose total number of registered voters is 16,640. When we are looking for substantiality, it is that number, because it is those that we do not know how they voted, vis-a-vis the margin. If we find that those whose electoral choice we do not know is greater than the margin, then the election is put in doubt. Why? Because we do not know who would have voted what, at which polling station, what voter turnout. The mere fact that is greater, therefore, has the capacity to change the result of the election. Not change it for the winner to lose, not change it for the loser to win, but as to put the election in doubt. That had to be underscored very critically. Now let me take you, Your Lordship, how the courts have applied this test standard. The Court of Appeal, how it has applied it, what exactly I am saying. I'll begin with Apollo County. Yes, I'll begin, my lord, with Apollo County. In volume 2, my lord, the holding that I want is at page 573. 573. What was the problem in that case, my lord? The problem was that results from 9 polling stations were not included in the final tally. Results from 9 polling stations were not included in the final tally. My lord, I was telling that is at page 573 of the second volume. We have read the first quantity, but we can just go back now for this point. 573. And we have highlighted, Your Lordship. Their results from 9 polling stations with over 5,000 voters had not been included in the final tally. The margin from the decade results was as low as 356 votes. Their lordships had this to say, my lord. In our view, in view of our finding above that the 9 polling stations had not been included, we do agree with the land trial judge that the outcome of the results of the whole Chadondo East constituency was left in doubt. The non-compliance, therefore, affected the outcome in a substantial manner, and the trial judge was justified in annulling the election on that ground. See, my lord, their lordships are not touching voters whose electoral choice is no. Only the 5,000 vis-a-vis the winning margin. And because the number of 5,000 was far greater than the winning margin, the lordships held that the election was affected substantially. I'll go to the next one, where this was applied as well. Wakaima Msoke Nsereko, my lord, the case begins at 831, and the holding is at 870. I think we are in the second volume, page 831, but the holding is at 870. I think it's something that that matter. And he lost this very point. Yes, but my lord, the holding is at 870. 870 is where the holding is. I was just reminding Mr. Willis that he lost this point in that case. There are your lordships at page 870. They said, we agree with the trial judge that the total number of 17,239 registered voters in the 24 affected polling stations whose results were cancelled affected the outcome of the result in a substantial manner. Again, only those whose electoral choice was not considered, not the total number of voters. Permit me, my Lord, again to take you to Betty Wamzanira Mkwasya. My Lord, permit me to take you back to Betty Wamzanira Mkwasya at page 755. The authority begins at Betty Wamzanira Mkwasya versus Winfred Komhanji. The authority begins at 744, but the actual holding is at 755. There, my Lord says the decision applies to this case after quoting content Apollo, which I have just referred to. They said the decision applies to this case. The returning officer neglected to tally a substantial number of votes totaling 5,413, and he disregarded the same in his declaration of the elected candidate. Certainly went to the root of the electoral exercise. It amounted to disenfranchisement of the voters whose votes were not considered in the declaration of the winner. Then down there it says, consequently, the disenfranchisement of those voters substantially affected the outcome of the election, since the results declared in the contained in the return form indicated a much lower margin of 4,000. Then Muhindo Rehema, my Lord. Muhindo Rehema versus Winfred Kiza, 90. Yeah, in volume 3, I think, my Lord. Page, the first authority on page 3. Volume 3, yes. The holding is at page 890, my Lord. There, my Lord, 13,426 had not been considered. That first paragraph on top, my Lord. And their lordship said that was significant to affect the result of the election in a substantial manner. Now, let me also say some of these legal points, my Lord. The first one, when we are determining substantiality, my Lord, the number of polling stations that the winning candidate has won vis-a-vis those of the losing candidate is irrelevant. As you saw, my Lord, from the theory of the first respondent, he attempted to tell us that, look, I have won in so many. I would have won in those others. Before I get to that, the number of polling stations that you have won is irrelevant. My Lord, I take you back to Mbaju Jackson at page 501. This is the second volume. Mbaju Jackson versus Tembo Gideon Mujungu, page 501 of volume 2 of our bundle of authorities. The actual holding is at 501. That case is the first one in volume 2. My Lord, paragraph 92. The lordships in the Court of Appeal say it is true that neither the applicant nor the respondent number 2 won at any of the disputed polling stations. Just like here, we don't know who won. However, this cannot lead to the conclusion that such malpractices did not affect the result in a substantial manner. The election is won by the total number of votes cast and not by the number of polling stations at which the candidate wins. So that issue should be out of the way. It should not disturb your analysis, my Lord. Secondly, my lord, the other point I wanted to emphasize on this issue as I walk away from it, it is irrelevant. It is theorization for the first respondent to say that because I won in the majority of the polling stations, I would have won even in those polling stations. And therefore, because he's saying that to say, my lord, that therefore the election was not or could not have been affected substantially. That theorization, my lord, when he came here in his answer and explanation and began talking about trajectories, patterns, and those kinds of things, my lord, I'm saying that is without legal basis. For you to say, my lord, that because I won there, I could have won there, that guesswork, as I called it, my lord, as a reason for saying that the election could not be affected substantially, is without legal basis. Adding the number of votes and subdividing, as Mr. Mbabas took my client through, is without legal basis. It's guesswork. And my lord, of course, it is not lawful that courts will not act on guesswork. They act on real evidence. For that, my lord, I've given you the decision of Okare versus R in our third volume, I think. Yes, in our third volume. Okare versus R. The page where the holding is 898. Okare versus R. It starts at 896, but the holding is at 898. There, my lord, the court was simply saying that courts do not act on fanciful theories. They act on real evidence. The reason, my lord, from the reading of the answer to the petition, the reading of the affidavit, my lord, if you followed the cross-examination of Mr. Mbabasi, the theory was simple from the first respondent. In the second, third group.
My lord, just forgot to follow. We don't have 898, the one being quoted.
You have
Our copy has 891. From there it goes to 916.
That's it. This is just saying it is there. The case is there. That one. Wait, right now. That case. I think the pages were misfired. We always we have both the violence. 898. My lord, the point I was making before I was hearing Mr. Sabganda is this: that this theory that the first respondent put in his answer and pursued in cross-examination, okay, was tending to show, the theory was to show that because of the patterns that he referred to, trajectories, guesswork, okay, he was saying that I would have won in those polling stations. But that's not where he stops, my lord. He's saying because of that he won in majority, I would have won in the 14, therefore the election could not be affected substantially. That's where he leads to. And my point, my lord, that I'm making with this decision is that theorization basis and cannot be a reason for saying that the election could not be affected in a substantial manner. Let me also make this third point, my lord, again as I walk away from this issue. What is at stake, my lord, if we first put the rights respondent? Let's also think about the 16,640 voters who were disenfranchised. These people went to vote. We don't know how many went. We don't know how many turned up. But we know that people turned up to vote at these polling stations. But their results are nowhere to be seen, my lord. They are not in the tally sheet. They were disenfranchised. My lord, can we say, therefore, that their votes don't count, that their votes carry less weight, that their votes are irrelevant. My Lord, their lordships in the Court of Appeal have said no, please don't treat them like that. This is the case of Mbagadi Frederick Nkai versus Dr. Frank Nyakuso. My Lord, that is at page 901, but the holding is at page 926. This is holding now. Three. The actual holding, my Lord, is on 926. Yes, but the authority starts at 901. My Lord, their lordships are saying, please also look at the 16. Don't only look at the petitioner and the respondent who wants to be in Parliament. There's something else at stake. It is the 16,640 voters whose electoral choice was not taken care of. And my Lord, disenfranchisement of these voters happened far from Mr. Muyizi's cross-examination of they voted so they were not disenfranchised. No. Disenfranchisement does not only mean being stopped from voting. It goes all the way. When I vote and my vote is not counted or not tallied or given less weight, I am disenfranchised, my Lord. That is Apollo Kantinti. I will go back that decision. I don't want to take it back and forth. But what I'm saying is in that decision, that disenfranchisement also goes as far as that. When you go to that decision, you will see the various highlighted parts. Now, my Lord, disenfranchisement is fatal. Disenfranchisement of a number as great as this, nearly double than the margin, nearly double the margin between the first respondent and the petitioner is fatal. The election cannot be upheld, my Lord. Kantinti, my Lord, is one of them. The other one I have is Atan Pokia. I think I also refer to it. My Lord, continue to have is that effect. My Lord, we have highlighted that particular part. I don't have to go back. You cannot give the 16,640 any less weight. Now, my Lord, with that, on this point, I invite you to find and hold fast that there was non-compliance with the provisions of the Parliamentary Elections Act relating to elections, and that non-compliance, my Lord, affected the result of the election in this country. I now, my Lord, I don't know if, yeah, I go to the next issue. The next issue is whether there was an illegal practice or any other offense under the PEA committed by the first respondent in connection with the election, personally or with his knowledge and consent. My Lord, under this ground for setting aside the election, we pleaded for illegal practices or offenses. I'll begin with bribery. Bribery, your Lordship, is prohibited under section 87, subsection 1 of the PEA. And my Lord, from a long line of cases up to the apex court, they have interpreted that section again and again and crystallized three key ingredients of that illegal practice. For me to succeed on bribery, my Lord, I should show you three things. Number one, that a gift was given to a voter. Two, that the gift was given by the candidate or his agent. Three, that the gift was given to induce the person to vote for a candidate. Once I prove that, my Lord, I have proved the illegal practice of bribery. My Lord, that is stated, what I've just said is stated in the case of Gaddafi Nasur versus Sekabila Dennis, quoting the decision of Kizames versus Museveni. Those ingredients that I have proof, my Lord, the cases are in third volume. It starts at 963, but the actual holding is at 987. The actual holding is at 987, but the authority starts at 963. My Lord, I'll go through the evidence of each incident of bribery. And I'll begin with that of Maumbe Jojo. I'll go through one by one, my Lord, evaluate the evidence, and then make a general comment on the law. I'll not speak about the law in each incident. I'll speak about the law generally. But I have first take you through the evidence, my Lord, for each incident. Now, I'll begin with Maumbe Jojo. This gentleman, on the 9th of April 2025, saw an affidavit for us, a petition. My Lord, I think in the examination you were able to note the numbers, the pages where that affidavit is. But for abundance of caution, my Lord, is at page 1276 to 1278. In that evidence, my Lord, this gentleman stated that he is a registered voter at Clinton Junior School KI2M polling station. My Lord, we gave that voter's roll as part of our evidence. On election day, he says that he met a man called Ben Nalukoola at Omar's place near a shrine under a jackfruit tree near a place called Zion Park. That place, my Lord, is found in Chiganda zone in Kawempe North constituency, not very far away from where the polling station is. He said that when he got there, he found Ben Mukasa giving money to several people, and he gave him 5,000 shillings and asked him to vote for the first respondent. My Lord, this witness came to the stand and was extensively cross-examined with his affidavit, and he remained firm that he was given 5,000 shillings by Ben Mukasa. Ben Mukasa also gave an affidavit. I said, my Lord, I refer to it without prejudice. He gave an affidavit where in paragraphs, my Lord, if you could note them, 6, 7, 8, 9, 14, and 15, he made repetitive bare denials of having given this witness a bribe. He simply says, I did not see. Bare denials, my Lord. He actually says to his face that I know these allegations are not correct because Maumbe has said in the second affidavit that they are not correct. Of course, thankfully, my Lord, that second affidavit is now out of date. For Chamber Nathan Mwangs, the second incident, again, the registered voter at Clinton Junior School, KI2M, we have given the voter's roll, my Lord. He says, that day of the election, he went to this parking lot and found Nachove and Ben Mukasa. Nachove gave him 10,000 shillings. Again, my Lord, the witness was cross-examined extensively, and rather than impeach, what was taken from that cross-examination, what I noted, is rather than impeach the fact that